it's all going to come down to whether or not he was in fear. And in this case, he had been disarmed of his taser. And I think that's pretty much undisputed. And so the question is that taser something that would cause fear to an objectively reasonable officer? And we wanted to show the jury what happens when you get tased. And, we still can do that in ways that don't involve an actual demonstration. The judge decided, I think, it was just too much of an atmosphere that would cause concern for her individual courtroom. So we'll do it through other ways. That's some testimony. We might have some videos of people getting tased. Really concerned that, Michigan, the legislature has never passed a statute, unlike almost every other state in the country, when it comes to when can a police officer be charged with murder for using deadly force when he's on duty and it's a lawful stop, and everything else he's followed his training. And so we're really in this common law area. And so what we were discussing on there is, what can these experts say? What's the standard and the lens to which they view what's a reasonable belief? And what the judge decided basically is we're going to have sort of a second hearing around the time of the trial, maybe during the trial, where the jury's not going to be present, but we're going to discuss what the sort of the boundaries for the experts are. So, it's stuff that lawyers are very interested in, but because this is kind of a case of first impression, especially in West Michigan, we hope to get that right before we actually have the jury deliberate.